Hi, Jody. Welcome to the show.
Hi, Jason. Great to be here.
Jody, I wanted to talk to you about your wealth of experience, obviously, but really on a lot of workplace investigations where someone may have done something wrong. Maybe there was a sexual assault or sexual harassment allegation. Can you tell us a little bit about your experience in that world?
Well, I've always handled a lot of gender bias cases. I've had a focus on gender bias. Sexual harassment is a form of gender bias, and public awareness of sexual harassment and the fact that it is alive and well 30 some years after laws were passed to prevent it
Right.
was really, everybody was awoken by the Me Too movement, where, women just worldwide reported the prevalence of sexual harassment, either presently in their workplaces or in the past. And from the sheer number of cases, we also learned that most women do not report
Right.
cases. So there's been an increased focus on everybody's part, on employee rights advocate, corporate defense attorneys, corporate management side attorneys, trying to get a handle on sexual harassment and actually do something about it, not just have check the box policies that aren't effective.
Right.
So since the Me Too movement in particular, there has been an increase of sexual harassment claims, and companies have increasingly, wanted audits, wanted advice about how to improve their culture, so as to prevent harassment. That just having a legal compliance is not enough. You've got to get to the culture.
Right. So let's talk about it in terms of a hypothetical. So say if someone's hypothetically reports that there was some type of sexual assault that happened at work, where we would come in as obviously represent the individual who's accused, but what would the company do, and what would your role be to try to figure out what happened?
Well, if the company hires me as an independent investigator, and these are all independent investigations, it is not covered by attorney-client privilege. It is a good defense. A good investigation is a defense. So you're writing to find the truth. I mean, you're investigating to find the truth. And in a case where there's a sexual assault, there's both obviously criminal liability that you
Right.
would handle or your firm, and there's civil liability also. And so depending on the severity of with the pending criminal case, the accused is not going to cooperate. The accused is going to take the fifth,
Right.
as properly he or she should. Where there's more of a gray area is where there's a sexual misconduct in the workplace, perhaps rising to the level of a sexual assault, but there are not necessarily pending criminal charges, or sometimes, a lot of times, these claims arise out of previously consensual relationships.
Okay.
So the civil piece of the case, when you don't have a criminally charged defendant charged with rape or sexual assault or other kind of sexual crime, the company is going to proceed with or without the accused's cooperation. And in all likelihood, if there's any corroboration to the plaintiff's claim, if the plaintiff's story is simply more credible than the defendant's, there's a real need to come to a conclusion, and to take remedial action. The law requires the company to take remedial action. So
Right.
one of the most effective remedial steps a company can take is to get rid of the harasser, to
Right.
terminate the harasser. And so all benefit, the harasser gets no benefit of the doubt here. Very different standard. It's preponderance, it's civil liability for sexual misconduct is preponderance of the evidence versus, beyond a reasonable doubt. And many companies also have respectful workplace policies designed to nip sexual harassment in the bud,
Right.
and an accused's conduct may violate a policy, if not the law. I mean, understand that the law of sexual harassment is basically any unwelcome behavior of a sexual nature that is severe or pervasive to the point that it alters the working conditions of the victim. That's the most common form of harassment. And so a single incident in the nature of a sexual assault, or potentially a criminal sexual assault, that satisfies the severe standard. You only have to have that happen to you once.
Right.
Where verbal contact, verbal comments, jokes, stuff in the office that shouldn't be in the office, that needs generally to be somewhat pervasive. Right. It's not both, it's severe or pervasive. And then certainly the other context where this comes up a lot is in Title IX on college campuses.
Right. So before we get to that, I definitely want to talk to you about the Title IX on college campuses, whether in this podcast or next, because this is another huge topic. But Jody, so a person's accused, there's a criminal investigation, maybe not actually charged yet, but there's an investigation.
Mm-hmm.
What does the company do? Can they suspend the person without pay? Do they have to pay the person? Like, what happens? What's the first step that's going to happen to that person's employment?
Well, that's a very good question. The first thing is that pending the company's investigation, and even if there is a criminal investigation, as you well know, it can take months and months and months.
Exactly.
Particularly in the context of coworkers, and formally consensual relationships. So a lot of time goes by before the authorities, get their act together. The company needs to act right away, and almost always the company will put the accused on a leave of absence. Used to be the woman got put on a leave of absence, but that's punishing the woman.
Yeah.
And I'm speaking about the typical genders in these cases, although it's not 100%, male on female. So the company will put the person on leave, depending on the severity of the facts. It may be paid leave, but it may not be paid leave either. And, for the most part, most employees, certainly in Massachusetts, are employees at will. They do not have solid contracts for a specific term, and even so-called employment contracts for a specific term have escape clauses to get rid of somebody who's not meeting company performance or conduct standards. So companies very quick to separate the alleged harasser and the alleged victim. And most companies will do paid leave, unless there's like a police report and it's just really in the nature of a sexual assault versus verbal contact. And then the company will investigate. I will interview can't interview the accused necessarily, depending on the person's attorney's position on the Fifth Amendment, but talk to the complainant, any witnesses of the complainant, look at company records, documents, anything to corroborate the charge, because many of these cases are he said, she said. And investigators can't throw up their hands and say, I can't figure it out. I mean, you're trained. I mean, I do HR training, or I did HR training on how to do internal investigations. And so there's a method to the madness. You first gather objective evidence to the extent it's available, email, text messages, security footage, time records, things like that to corroborate. Then you take the victim's story, and the investigator, in almost all cases, needs to make a determination, get to the truth. And that's what's refreshing for a lawyer, a litigator, such as myself, to be in a process that's really designed to get to the truth and not hide behind privileges or anything like that. It's a refreshing way to do business. It really is a truth-seeking process, and it used to be companies hired investigators to whitewash the story, and this could be discrimination as well as sexual harassment, but that does nobody any good. A good investigation can nip the problem in the bud, or send the person to training, all kinds of remedial measures. Letting it fester and then go to litigation is not in anybody's interest. So companies should be hiring good independent investigators who know how to interview witnesses, as typically litigation lawyers do, and to try to get to the truth as by a preponderance of the evidence standard, which makes life a lot easier than your job. A prosecutor's job maybe of getting.
It's good for us. It's good for us, Jody.
Yeah, proof beyond a reasonable doubt. Yeah. And there's there's some controversy, but no, preponderance is the civil standard. If the scales of justice tip, 0.1% in favor of one side or the other, you're done. You've done your job. So there are not a lot of employment rights for people accused, particularly in sexual misconduct situations in the workplace.
So, Jody, people don't just hire you as an outside investigator. What are some of the other times when people should be contacting you via your website or email? We have it all here. When should be people calling Jody?
Well, I'm a veteran employment lawyer. I've been at this for more than 35 years. I practiced almost exclusively in a boutique firm before we went global. And I, in the beginning of the pandemic, joined Boston Law Collaborative, where I am of counsel. So, any difficult issue involving Me Too, Black Lives Matter, Stop Asian Hate, I will do advocacy on behalf of employees. I will advise companies how to, get their act together and clean up their workplace culture. And I'm a trained mediator, a great big believer in early resolution to these problems. They should not fester in lawsuits. And, just your standard employment matters, non-compete agreements, contract. But my sweet spot is discrimination. I deeply understand the law and, more importantly, the dynamics of the workplace that give rise to this ongoing discrimination and harassment that we see because the past policies and practices just haven't worked.
That's wonderful. Thank you for coming on today, Jody. I definitely want you to come back to talk about Title IX soon.
Yeah, that's a whole other can of worms. Yes, great. Thank you. Thank you so much. Thanks for having me, and I hope to see you again soon.